5 seconds to go. Start. While evaluating whether specific performance ought to have been decreed in the present case, it would be necessary to bear in mind the fundamental principles of law. The court is not bound to grant the relief of specific performance merely because it is lawful to do so. Section 21 of the Specific Relief Act 1963 indicates that the jurisdiction to decree specific performance is discretionary. Yet, the discretion of the court is not arbitrary but is sound and reasonable to be guided by judicial principles. The exercise of discretion is capable of being corrected by a court of appeal in the hierarchy of appellate courts. Subsection 2 of Section 20 contains a stipulation of those cases where the court may exercise its discretion not to grant specific performance. A perusal of Section 20 of the Specific Relief Act 1963 as it then stood would go to show as to under what circumstances hardship can be taken into consideration in refusing specific performance. It is not possible to enumerate the different circumstances which constitute a hardship. It will suffice if it is noted that the question of hardship will have to be adjudged in the facts and circumstances of the case. In this connection, the observations of the Privy Council in the decision reported in 1911 SCC Online PC 25 throw light on an important aspect of the matter. Among other things, it is observed in the said case as under. In the absence of any evidence of fraud or misrepresentation on the part of the plaintiff which induced the defendant to enter into the contract, their lordships see no reason to accede to the argument. The bargain is onerous, but there is nothing to show that it is unconscionable. The defendant knew all along that a lakh was the plaintiff's limit. It is in evidence that he had frequently urged the defendant's daughter to advise him to sell the land if he was getting a higher offer. It is difficult to say under the circumstances that he took an improper advantage of his position or the difficulties of the defendant. Then again, it is necessary to remember that mere rise in price subsequent to the date of the contract or inadequacy of price is not to be treated as a hardship entailing refusal of specific performance of the contract. Further, the hardship involved should be one not foreseen by the party and should be collateral to the contract. In sum, it is not just one factor or two that is relevant for consideration, but it is the sum total on various factors which is required to enter into the judicial verdict. The High Court seems to have been carried away by the fact that in the written statement the defendants did plead that hardship would be caused if they would be asked to execute the sale deed of the suit property. The trial court had not framed any issue as regards hardship that may be caused to the defendants. It is also pertinent to note that the High Court concurred with the trial court on all other issues, but thought fit to reverse the decree only on the ground that if the defendants are asked to execute the sale deed of the suit property, that is the residential house, they would be rendered shelterless. In the aforesaid context, we may refer to a decision of this court in Prakash Chandra versus Narayan reported in 2012 5 SCC 403, where in para 17 of the report it has been held. The question as to whether the grant of relief for specific performance will cause hardship to the defendant within the meaning of clause B of subsection 2 of section 20 of the Specific Relief Act 1963 being a question of fact. The First Appellate Court, without framing such an issue, ought not to have reversed the finding of the trial court while concurring with it on all other issues with regard to the appellant's entitlement to relief for specific performance of contract. Thus, in view of the aforesaid, the High Court committed an error in taking the view that the plaintiff is not entitled to the decree for specific performance, as the same would cause hardship to the defendants. The High Court seems to have overlooked the fact that the question of hardship in terms of Section 22B of the Act 1963, read with explanation 2, bears reference to hardship which the defendant did not foresee at the time of entering into the contract. In other words, the issue of hardship would come into play only if it is established by cogent evidence that late Prabharanjan Das, who executed the agreement of sale, was unable to foresee the hardship at the time of entering into the contract. The explanation elucidates the point of time at which the hardship has to be determined with reference to the circumstances existing at the time of the contract, except where the hardship has been caused from an act of the plaintiff subsequent to the contract. There is nothing to indicate in the pleadings or evidence that there was a hardship of the kind which late Prabharanjan Das did not foresee at the time he executed the agreement of sale, or that the hardship which the defendants herein would face is the result of an act of the plaintiff based on his supervening acts. Stop.